Justice Alito and others had to push hard. The records and interviews show some steps, like his apparent selective preview of the draft opinion, were time-honored ones. But in overturning Roe, the court set aside more than precedent. It tested the boundaries of how cases are decided. Melissa, let's start with the how rare and significant this report is. How often do you see an expose like this that goes behind the scenes on Supreme Court deliberations?
So this is pretty rare, although I will say that Jodi Kantor, one of the authors of this report, has also been doing a lot of behind-the-scenes reporting on the Supreme Court. She was also one of the co-authors of the November 2022 report about influence peddling at the court, conservatives trying to gain access to the conservative justices. So we are getting, I think, more behind-the-scenes looks at the court, but they're not really great looks. And this one is especially bad because it makes clear that the real issue and the real pivot point behind the court's decision to overrule Roe versus Wade and Planned Parenthood versus Casey was not a question of law, but the fact that Ruth Bader Ginsburg died in September of 2020, creating a vacancy that could be used to add another conservative justice, and therefore a pretty solid block to overrule both of these landmark cases.
But according to this report, Justice Neil Gorsuch signed on to Alito's 98-page opinion to overturn Roe just hours after it was released. And Justices Thomas and Barrett and Kavanaugh signed it the next morning, all signed without any alterations, any edits. What do you make of that?
Well, as someone who has clerked on an appellate court, I think it's really rare that something gets circulated, especially an opinion of this kind of magnitude, and everyone is like, perfect, 10 out of 10 no notes, or even that it could be read. This was an over 98, this was a very large opinion. I think it came in close to about 98 pages in the end. And Neil Gorsuch apparently read it in 10 minutes. So to me, that suggests that he either saw an earlier version or the final version of the draft in advance of it being circulated among the justices, and he was on board and merely gave his assent at that point, or that he didn't read it at all and was just in the bag for this outcome. Either way, neither is a good look for this court. And I imagine this reporting is, you know, again, another part of John Roberts' no good, terrible, very bad year at the Supreme Court.
Earlier this week, the Supreme Court decided to review the mifepristone case, putting the future of abortion access back in the hands of the Supreme Court. What are you watching out for in that case?
Well, one thing I'm watching out for is whether this court was serious when it said in Dobbs that abortion was an issue that should be left to the states to decide for themselves, because a ruling on the mifepristone case would essentially be a federal ruling deciding whether the FDA was acting appropriately when it authorized this drug and subsequent reauthorizations of it and subsequent new rules regarding its distribution. That's a federal national decision. Dobbs was supposed to be a decision about abortion at the state level, ending a national right to an abortion and instead returning this question to the states. But as many in the pro-life movement know, the fact that medication abortion exists allows individuals to access this in a way that can often go undetected by state authorities. And that really is the chink in the armor for those states that have really draconian abortion laws. And that's why they are so pressed to get rid of medication abortion. And if this court signs on to that program, I think they will be undermining and making clear that their ruling in Dobbs was not truly a state-by-state settlement of this issue, but merely a way station en route to a more permanent resolution, the elimination of broad access to abortion in the United States.